let's talk about what do we know? What's the low-hanging fruit here? What is it that we actually know about social media discovery? Well, probably the easiest one is going to be this one. There is a duty to preserve everything. You know, it doesn't matter if we're talking about social media, emails, paper documents. Courts have been pretty uniform in holding you're engaged in litigation. If you've got that reasonable expectation of litigation coming down the line, you're under a duty to preserve. If you're out there deleting your Facebook posts, editing things, shutting down Facebook, shutting down your Facebook account, that's going to be problematic, and it's going to get you into trouble because courts are starting to recognize it's the same rule. Duty to preserve applies no matter what type of media we're talking about. That's low-hanging fruit number one. Low-hanging fruit number two. Show of hands, especially the people on the phone. I want to see your hands. How many people think that just because you put your privacy settings on Facebook where people can't see it, that's going to affect the discoverability of the information that's at issue here? So, hey, privacy settings, it's private. I'm not going to give you discovery of that information. I see a lot of hands going up. None. Okay. So let's see. Privacy settings do not trump the discovery rules. No matter how the courts are coming down on what's discoverable or not, this is an argument that's been raised countless times by parties that are resisting discovery into social media. And it's an argument that's been shot down every single time. I mean, I can't find a single court out there that says, well, it's private settings, so no discovery of it. And we have a couple of examples here in the presentation. You know, one federal court, one state court, but no matter where you go, you're going to find this exact same case law. All right, what else do we know that's actually clear? Well, this is a good one. Let's say you're involved in litigation and Corey over here, my opposing counsel, she's a real pain in the ass. I can't get anything out of her. She's just going to object to everything. But I really want her client's Facebook account. Can I just go directly to Facebook and say, give me everything that her client has posted? Who thinks that I'm going to be able to get away with that? A lot of hand raisers here today. All right.
Ask them why not. How many know why?
Right. Does anybody know why? Okay, never mind. All right. So this is Facebook's response when you send them the subpoena. This is actually a live recording of how Facebook is going to respond to you. And why is Facebook going to respond like that? Let's see what he's actually pointing to. The Stored Communications Act. This is a federal statute. Basically what it says is that electronic communication services, remote communication services, they can only provide communications or information about a particular user to the user or at the user-specific request. So if you send a subpoena to Facebook, and in fact, Facebook is probably the one that's most leading the charge on this. Facebook actually has this. If you Google Facebook subpoena, they've got it right on their website that says, here's what we're going to respond if you send us a subpoena, and we're going to crush you in the process. They make it very clear they're not going to respond. And so examples of this, probably the leading example is this top case here, this Crispin case, and it's out of the Central District of California. Note, that's where Facebook is. So, you know, in this one, what you had was the plaintiff that sued, the defendant said, I want to serve a subpoena. Much like Florida, it's if you want to serve a subpoena, you got to get a judge's permission before you actually serve it. The plaintiff objected, and the judge said, yeah, you're not going to even serve this subpoena on Facebook because the Stored Communications Act absolutely blocks it. And you'll find this case here gets cited pretty much in every case where either Facebook's resisting the discovery or where a party is resisting the discovery on Facebook's behalf. Now, on the flip side of this is you've got this Ledbetter case v. Walmart back in, I think, 2009 in the District of Colorado. Same situation. You had a plaintiff saying, no, you shouldn't be able to get access to that information from Facebook. And the court said, no, I disagree. The defendant can serve the subpoena. Now, I guess the ultimate question in that case, and it's, I didn't see what happened after that, is you can't serve a subpoena on Facebook in the District of Colorado. You're going to have to take it to the Central District of California. You're going to have to serve it over there. And I assume Facebook made the same arguments they did in the Crispin case. So I don't know whether Facebook was ever ultimately compelled to make that production, but it seems pretty clear based on the cases that I've seen. The Crispin way of doing things, if you want the documents, you've got to get it from the actual party itself, is the way to go. Now, what it raises an interesting point is that, let's say we are involved in this litigation, Tori and myself, and I know that Tori's client has deleted things. You know, certain relevant posts, I saw they were there last week. They're not there this week. And now I say, go get those things back. And her client says, well, look, there's no way for me to undelete things that I had on Facebook. My status updates are gone. My assumption is Facebook actually has all of that stuff in some computer somewhere. And so the question is, what would a court do in that situation? I haven't seen that case come up where I know there's been spoliation of evidence. I think Facebook actually has it. Can I force Facebook to actually produce that deleted documentation?
The court can compel placement for the party, whatever. What?
Right. What a court can do is, at least in Florida, a court can require, I can't think of the name of the form, but it's like an authorization for consent. A court can compel a party to sign a document, send it to Facebook, that says you may release the information to this party.
Not fall under the article that should be the intended recipient, the argument to the whole world?
Well, it falls under the Stored Communications Act if something is in temporary or intermediate storage. And so, you know, if it was a public post on Facebook servers, it's still in storage. It's not something that is in the process of being sent. You know, as soon as you post it and it goes onto that wall and it's moving down the line, it's in storage somewhere on Facebook servers, which is what the courts have said. You know, it meets the definition of the Stored Communications Act, and therefore you're not going to get it from Facebook. I mean, obviously, if it was on the public wall and you saw it and it was there and you copied it, you don't need to go to Facebook. The question is what happens when it actually gets deleted at that point. And I don't know the answer whether Facebook even has it or not. Facebook changes its policies every couple of months. I know as of a couple months ago, you could go onto Facebook, an individual user could go onto Facebook and download their entire profile, all of their posts, all of their activity. I read online that a couple months ago, Facebook actually disabled that and no longer has it up there. So, you know, what Facebook used to say was just tell them to go push this button, click here, and download everything and give it over to you. Now that it's gone, I don't know what the Facebook response is going to be.